Great. So, welcome everyone. Today I have with us a very great friend and a great professor, Professor Anthony Casey. Professor Casey is an expert on business law, finance, and corporate bankruptcy. He has published widely in leading publications such as Yale Law Journal, Columbia Law Journal, Supreme Court Law Review, etc. Before entering academics, Professor Casey was partner with Kirkland and Ellis in the United States. He received his JD with high honors in 2002 from the University of Chicago, where now he serves as Deputy Dean and Professor of Law at the Faculty of Law and at the Center of Law and Finance. Professor Casey's work in bankruptcy has been a great guidance for India. I'd also like to share that he has been a regular attendee and a speaker at the prestigious EMF Emerging Market Finance Conference, which is organized by IGIDR and Vanderbilt University. And it is a great honor and a pleasure to welcome you, Prof. Casey. Now I hand it over the floor to you to take this discussion forward. Thank you.
Great, thank you. Thank you for having me. This is great to be here. And I'm really excited to participate and present my paper. There it is. Okay. I'm very excited to present today. I think I'll jump right in. The presentation I have is what I'm calling our own private bankruptcy. And what I'm looking at is this phenomena of private agreements over bankruptcy process, where creditors, sometimes the debtor, sometimes not the debtor, just other parties, enter into an agreement where they change the procedural rules or they dictate how they're going to behave in a bankruptcy process. And what I want to present is kind of a literature review and kind of a current development. So I'll talk about what experts have written about this, but also some cases that have kind of demonstrated the importance of this. And there's different types of agreements I'll focus on. The reason I want to talk about this topic is I think it's actually very fundamental. So it might seem one narrow issue, but if you looked at, for example, the kind of 15 most recognizable names of bankruptcy professors in the US, I think you'd find at least 10 of them have written about this issue. If you talk to judges, they would tell you that almost every large corporate bankruptcy presents a question of how to interpret, how to enforce these agreements, these side agreements that dictate how bankruptcy process works. And I also think this topic gives kind of insight into a fundamental question about bankruptcy theory. And by that, I mean, if you look at the way private parties dictate their own behavior in a bankruptcy system, that can tell you one of two things. It can tell you the efficient way of doing things, because look, this is the way the market wants to do it. Or it can tell you, look, here's private parties trying to get around the rules, and maybe we need to make the rules a little stronger so that they can't get around those rules. And so those are the two questions you want to ask when looking at these topics. Okay, so if you, there we go. So I want to start with some background. I'm going to focus, as I said, on Chapter 11, agreements within Chapter 11, within the US system. But I do think the lessons from this and the questions are fundamental to all bankruptcy systems. But just to give a background for people who might be less familiar with the US system, Chapter 11 is our corporate bankruptcy provision, and it is a debtor in possession system. So unlike in India, the debtor is the one who really keeps control once the process begins. The debtor usually makes the decision to enter the bankruptcy system. Now, creditors can force involuntary bankruptcies in the US, but very few do. The numbers are less than, somewhere around 1 or 2% of bankruptcies in the US are involuntary. The debtor chooses to file. And once the debtor files, the debtor has formal control of the process. So for a certain period of time, only the debtor can propose a plan. The debtor decides the motions and things to put before the court. Many have pointed out, however, that as a real matter, other parties can sometimes exercise control indirectly. So Ken Ayatt and Ed Morrison have a paper from about 11 years ago where they study the control that senior creditors exercise. And senior creditors gain the control by threatening defaults, threatening acceleration of debt, kind of insisting on certain measures to be met in bankruptcy or certain parties to be involved. And so you have a process run by the debtor kind of ostensibly, but with others in potential control. All right. Now, the background rule is that bankruptcy is a mandatory system in the US. But I say in the slide, mandatory-ish. What I mean by that is, from the ex-ante perspective, there's a lot in bankruptcy that is required. So, for example, the debtor cannot waive the right to file bankruptcy. You can't say, I promise you'll never file for bankruptcy. The debtor cannot enter into an agreement that says, we're going to change the rules in bankruptcy so there's no automatic stay. We're going to change the rules about how you vote for a plan to get approved. Or we're going to change the US has a prohibition on ipso facto clauses. That's clauses that are triggered by bankruptcy. The debtor can't waive that. And so it's mandatory in that sense. On the other hand, once the debtor files, the system is broadly thought to facilitate ex post bargaining. So there's a large area of discretion where the parties can say, the rule says we're supposed to do this, but now that we're here, let's do something else instead. And so we can consent to something else other than in the rules. David Skeel and George Triantis have pointed this kind of dichotomy out in a recent paper where they say the bankruptcy code in the US really favors ex post contracting rather than ex ante contracting. Everything's mandatory ex ante, but not ex post. Now, why is that the case? I've written recently that the fundamental point of bankruptcy is to solve a holdup problem that arises when people abuse or take advantage of incomplete ex ante contracts. Well, if the problem is ex ante contracts, it makes sense that you're not going to let the parties get out of the solution through an ex ante contract. And so that's, I think, the reason why we see ex ante contracts being kind of disfavored in bankruptcy. There are others who criticize this. They say markets should decide what the rules are. We should let parties design their own rules. Bob Rasmussen has a paper in the 90s about that. And as I say, David Skeel and George Triantis, in their paper pointing out the dichotomy, they suggest the system would be better if it had kind of more emphasis on ex ante contracting. That's the kind of state of the view of the rules. But all rules have exceptions. There are ways to work around the bankruptcy's mandatory rules. So the most familiar and common in the US are entity partitions and special purpose entities. So we say a debtor can't agree not to file for bankruptcy, but a debtor could create a separate legal entity that holds a certain asset. Now you have two debtors. So if this debtor goes into bankruptcy, this one might not. And if you do certain things and create certain rules, you can make it really hard for that second entity to file for bankruptcy. And so you get what's called special purpose entities. And people have written about how these are ways to opt out of the otherwise mandatory system. A bunch of recent cases have highlighted other mechanisms. There's something called a golden share. And the idea here is you can say, oh, this debtor can only file if a certain class of shareholders vote in favor of it. And then you give those shares to a particular party, often a lender, a creditor. And you say you can't file unless that group of shares votes in favor. You've now created a veto right, a way out of the mandatory system. Courts are struggling with whether or not to enforce those. And some courts will say, well, it depends on who holds the share. If it's a creditor, we're not going to let them veto. If it's someone who's really an equity investor, we might. You can give certain parties board seats. There are all these ways to try to work around the mandatory nature of the bankruptcy code. I want to focus on one group of ways, and that's side agreements. So side agreements, this is the idea that we can enter an agreement that either opts out of certain procedural rights, dictates certain procedural rights. There are three buckets of agreements. The first bucket is ex ante, right? Ahead of time, parties enter into an agreement. The most common form of that are intercreditor agreements. So here it's not the debtor promising not to file for bankruptcy. Rather, it's one creditor saying to another creditor, you have to agree that if bankruptcy happens, you won't do X, Y, or Z. That's the fundamental nature of the intercreditor agreement. And then something I'll call, I'm borrowing a term from Professor Andrew Verstein, ex tempore. In real time, you can have agreements that while the bankruptcy is happening or right before it, do similar things and dictate how people behave. That includes what's commonly referred to as restructuring support agreements, agreements where parties say, if the debtor does certain things and if certain creditors do certain things, we all will support one plan of reorganization. Sometimes these are also called plan support agreements. Another version is DIP financing agreements. One lender says, I will lend money to the debtor to finance the debtor in possession, the DIP, to finance them while they're in bankruptcy. But they're going to agree to all these various things to avoid a default on that agreement. And that's a way to exercise control and change the procedures in bankruptcy. Again, you're not saying the rules are different, but the parties are saying, well, we're not going to do what we're allowed to do on the rules. We'll do certain other things. The last category would be ex post settlements and structured dismissals. At the end of the day, the bankruptcy says this creditor gets paid first, then this creditor. They can always settle and agree to say, well, actually, this creditor won't be fully paid and this one will get something. That's a negotiated ex post settlement. I'm not going to focus on that third category, although I'm happy to talk about that in the Q&A. But I want to focus on the first two. So the first category is intercreditor agreements. And the next few slides are based on work that I have done with David Skeel and Ken Ayat, where we looked at the problem, the phenomena of intercreditor agreements. So my favorite example of these is the first Radio Shack bankruptcy. So Radio Shack went through bankruptcy twice in recent years. The first time, they sold their assets to one of their creditors. And that sale was highly contentious. And the way parties were arguing about whether to allow it was through invoking intercreditor agreements. So in this slide, you can see kind of a confusing setup. What you had was a group of creditors secured with priority on certain assets. That's what the ABL group. Then you had a group secured with priority on another set of assets. That's where we see SCP. And then you had your other creditors. Those two groups had an agreement between each other that dictated how they would behave in bankruptcy. But to complicate things further, each group was itself divided into subgroups. And those subgroups had agreements among lenders that dictated how they would invoke the first intercreditor agreement. So if you see on the far right where it says agreement among AAL1, that's an agreement between those first two groups that dictates how they invoke that intercreditor agreement between the larger groups. What made things really complicated is that green circle, the uppermost green circle, where it says second out ABL, they wanted to buy Radio Shack. The first out, that yellow circle above them, wanted them not to buy it. And then the green at the bottom favored the sale. That's where it says first out SCP. And the yellow at the bottom, second out, didn't want the sale to go through. And so what happened was the second out said, we want to buy it. The first out said, we are going to invoke the intercreditor agreement to stop you. The second out at the bottom, the yellow, said, we're going to invoke our lending agreement to stop you from invoking the intercreditor agreement. And then the first outs at the top tried to use their agreement among lenders to stop the second out ABL from entering the sale. And so you had these coalitions and three intercreditor agreements, very confusing, where they're all trying to kind of use their agreement to either stop the sale or put it through. The court had to decide which agreements to enforce. Ultimately, it enforced some of them, but not all of them, and the sale went through. And so if you look at what courts have done with these agreements over the years, our paper does that, you can see that early on, in a few cases, courts didn't enforce them. That's 203 North LaSalle, Hertz. Then they started enforcing them according to their terms. More recently, you see courts in Boston Generating and Memento saying, we're going to enforce them, but only if they're extra clear. We're not going to treat these like normal contracts. It has to be very clear what you said the other party could or could not do. Then, if you look at cases, you might see, as in Radio Shack, that there's not necessarily a rule of how to enforce them. Rather, there is a kind of outcome-oriented view that we're going to enforce the agreements that help the sale, maybe not the agreements that hurt the sale. And a quote from the Radio Shack bankruptcy from Judge Shannon captures this, where he says, this is to one group trying to use their agreement to block the sale. I know your client has rights, he says, referencing the agreement, and I'm not trying to stick anybody, but you have to appreciate how difficult it is to stomach. What he means there is how difficult it is to let your one agreement stop, $100 million worth of sale that is the only good outcome for this debtor. And so I can't enforce that agreement, but maybe I'll enforce the others. So what should courts do? What should they do when they see these agreements where the creditors are trying to dictate the process? And to be clear, these agreements will say something like, the junior creditor is not allowed to buy assets in a bankruptcy sale. The junior creditor is not allowed to propose a plan. The junior creditor is not allowed to provide financing. Now, the benefit of that agreement is the senior creditor might be worried that the junior creditor is trying to extract value and hold things up. The senior creditor might say, ex ante, I don't want to give you the ability to try to throw a wrench in the reorganization, so you're going to be silent. You're going to be a silent junior creditor. And I want to keep you from creating alliances from others to take value and block a valuable sale or propose a sale that isn't valuable. So that's the benefit of these agreements. But the flip side's a problem as well. The senior creditor might be the one trying to extract value. The senior creditor might be trying to prevent a junior creditor from taking actions that do create value. Maybe the senior creditor wants to buy the debtor cheaply. So they say to a junior creditor, you can't bid. You can't provide financing. I want to provide the financing and then buy the firm out of bankruptcy. I want to veto the value maximizing outcome or threaten to veto it in order to get a payment from the debtor. And so given that there's two sides to this problem, and the way to think about it is if you over-enforce inter-creditor agreements, the junior creditors will under-assert their rights, which is bad if they're adding value. If you over-enforce agreements, then they under-assert. If you under-enforce the agreements, the junior creditors over-assert their rights. And that's bad if the junior creditors are trying to destroy. In a perfect world, courts will know who is acting opportunistically. But in the real world, they don't. And if they did, they would just decide the most efficient outcome. But they don't know that, and so they see parties invoking agreements, and they have to decide what to do about that. The solution that I have proposed with my co-authors is that you enforce these lightly, and in that sense, I mean you don't enforce them with specific performance. You don't say to the junior creditor, you're not allowed to speak. You're not allowed to propose something. That would be the specific performance. You might, though, say you're going to have to pay damages if it turns out that you propose something inefficiently. The reason for that rule would be the error costs are asymmetric. If the junior creditor has a really good plan or a really good financing proposal and never proposes it, the court will never know about the option. And so you lose this valuable possibility. If the junior creditor over-asserts, meaning the junior creditor says, here's a proposal, and it's a bad proposal, the court's going to have to sift through that and spend time kind of figuring out if it's a good outcome. But courts are better at sifting through bad proposals than they are at imagining proposals that have never been put before them. And so you have this asymmetry. The cost of over-assertion is extra procedure. The cost of under-assertion is you never save the debtor. You never get the financing. And so you want to enforce for damages. The junior creditors have to pay for that extra procedure, but not specific performance where you say you have to be silent. We won't hear you at all. That's the proposed solution. I think some courts are going that way. It's consistent with other things we do in bankruptcy. A lot of bankruptcy, at least in the US, a lot of Chapter 11 is you have rights. You're not allowed to assert them, but you'll get paid for them. Outside of bankruptcy, you were allowed to foreclose on an asset. You're not allowed to do that anymore, but you absolutely get paid the value of that asset. And that's the way to think about what we're also saying is you're not allowed to specifically silence the junior creditor, but you get paid if they speak out of turn, if you will. That's an ex ante agreement. What about when there is no ex ante agreement and the debtor is about to file for bankruptcy or just filed for bankruptcy? That's where restructuring support agreements come into play. So restructuring support agreements have become a kind of increasing phenomena over the last 20 or 30 years. These are agreements between the key players, sometimes, often including the debtor, sometimes just the main creditors. The key players agree how the bankruptcy is going to proceed, and they agree how they're going to vote on a plan. And again, usually, as I said, it will involve the debtor. Maybe the debtor reached out to one group of creditors and said, let's get this agreement in place where we all agree to a certain outcome. The debtor will often then make certain promises. Say, I'll propose a plan on a certain date. I'll meet certain milestones. And the creditors say, great, and we'll vote that plan. Maybe one of us will provide financing. But we all have entered into an agreement to support this one procedure, this one plan. The benefit of these agreements is they speed up the reorganization. If the key players have signed on to the basic terms of the plan before the debtor even files or right after it files, you're not going to have as much kind of unknown negotiation and bargaining during the bankruptcy. Moreover, you bind the parties to this agreement, which means that no one can at the very last minute try to hold out. Or you could imagine if it was a handshake deal, not a real contract, one creditor says, I love that plan. Let's spend 10 months getting that plan in place. All the money is spent doing that. And then at the last minute, they say, I'm not going to vote for it. You give me an extra 1%. Right? If that happens, they're extracting value. The restructuring support agreement can prevent that. The flip side, there are costs. It might be that these agreements are facilitating holdup. On the eve of bankruptcy, creditors are threatening certain actions, and they say, we won't do that if everyone agrees to support this plan where we benefit, where we get control and we get to decide what happens to the debtor because we want to take value out. They might be trying to extract value from outsiders who aren't party to the agreement, right? If there's 5 key players and 4 enter the agreement, they might do that to move value from the 5th. And it can cut off information to the courts, just like intercreditor agreements. If you have an agreement that says a certain creditor is not going to put information forward, that can provide this problem. All right. Douglas Barrett has written about this. Ted Janger and Adam Levitin have written about this. The Academy's been a little slow writing about it, but those are those 2 articles are the big ones. Douglas says, these are probably mostly good unless they're really cutting off valuable information to the court, and we've got to police that. Janger and Levitin are less optimistic. They think that these can be tools for opportunistic behavior, and you should look for badges of opportunism, they call it. One provision in RSAs is interesting and maybe could be viewed as a badge of opportunism, and that's what's called death traps. That's the lingo among bankruptcy practitioners, is to call this certain provision a death trap. Why is it called that? Well, what you put in the restructuring support agreement is a provision that says we're going to give special compensation to anyone who joins the agreement. But if you join, you're going to get something less. Right? So all the first, or let's say all the first lien lender, or all the groups of the first lien lending group, or all the groups of the bondholders who sign on, they'll get X compensation. Everyone else is going to get Y for not signing up. If Y is bad enough, that will coerce parties into joining the agreement, even though it's bad for everybody, because I don't want to be the one left out. So you'll get something bad or you'll get something worse, so agree to something bad. That's the bad side of death traps. The argument in favor is, again, if one group of creditors are holding out to the efficient plan, we want to force them in. We want to coerce them, not because we're bad, but because they're acting inefficiently to destroy value. That's the dilemma of a death trap. Courts tend to enforce them, which you can take that as being courts not understanding that it could be bad, or courts knowing that they are actually valuable. To give you, again, a current case that talks about, or that demonstrates what's going on with restructuring support agreements, Momentive was a major US bankruptcy that had a very interesting death trap. The second lien lenders agreed to an RSA with the junior lenders, agreed to an RSA with the debtor. In that restructuring support agreement, the senior lenders who joined the restructuring support agreement would waive certain arguments. So the junior lenders and the debtor said, let's enter an agreement and we'll ask the senior lenders to join. Any senior lender who joins will give up certain arguments that they would otherwise have. If they do that, they're going to receive cash for their claims right now. They'll get paid in full cash. If they don't agree, they won't waive those arguments, so they can make certain procedural arguments, certain other claims that they think they have. But if they do that, we're going to bring them down and pay them over time, and we're going to use an artificially low interest rate. There was a quirk of bankruptcy law that allowed a cram down, a payment over time with an artificially low interest rate. So if you agree to the RSA, you get cash, the full value of your claim. If you don't agree, you get payments with a low interest rate. That's a death trap. It coerces you to try to join the agreement early on and waive those arguments. Now, as a side note, there was an intercreditor agreement dispute as well. The senior lenders said that the junior lenders weren't even allowed to enter into that agreement weren't allowed to enter into that RSA because it violated an intercreditor agreement. The court struggled with this, and what the court ultimately said was, I'll get to that next slide. This is just a visual of it. You can see that you had the senior lenders, you had your junior lenders, you had an intercreditor agreement, and then you had the side deal between the junior lenders and the debtor, which is the restructuring support agreement. The courts struggled with this. It went up on appeal to a higher court. In the end, the intercreditor agreement wasn't enforced because, like I said earlier, the court said it had to be extra clear and it wasn't clear enough. The death trap was okay in principle. You're allowed to have a death trap. But in this particular case, the artificial interest rate was not allowed. So ultimately, the death trap was okay, but you're not allowed to have a death trap that gives an artificially low interest rate. It would have to give a market interest rate. So instead of saying cash or low interest, you could say cash or market interest, which at least still makes you wait for payment. All right. What's interesting about restructuring support agreements, as I mentioned earlier, is they've increased a lot over time, and practitioners were very aware of them. The academy's a little behind. There's those two theory articles. I have a working paper with Fred Tung and Kate Waldock, where we're trying to kind of look at empirically what's in these agreements and what has happened to them over time. This is an early project, so I'm just going to share some preliminary results. We gathered a sample of RSAs for all large bankruptcies over the last 20 or so years. and we looked at what's in them and how they're being used. The most simple thing is just to look at how common they are. So in our sample of large bankruptcies, you can see in the late 1990s, very few cases have these. It's less than 10%. But over the last 20 years, it's gone to almost 60%. There's a spike in around 2010, and then it's leveled off around just under 60%. So these are very common in major Chapter 11s. And again, this is looking at the large Chapter 11 cases. That's the frequency of the agreements. Then what we looked at was, kind of how long are these agreements and how long are the terms in them. And so this graph shows you the number of characters in certain parts of the agreement. So how many words, we use characters, but proxy for words, how many words are in your section on termination events? How many things in the agreement will say that if the debtor does X, everyone gets to walk away from the restructuring support agreement? What are the commitments the debtor makes? What are the commitments the non-debtors make? And so you can see these three lines over time, all of them are increasing. The termination events go up. Those are the longest provisions. The debtor commitments go up most steeply. They're kind of flat first and then they increase, and the non-debtor commitments are increasing over time. This tells us, I think, two things. One, the agreements are getting more complicated because the parties are getting more sophisticated. But it might also tell us, and this is where we want to go with this project, that there's more control being exercised. There's more debtor commitments being put in place. And that might tell us something about the way creditors are acting in order to dictate the bankruptcy process. Again, to kind of create their own rules for the bankruptcy. Now, another way to see that exact phenomena is to look at debtor milestones. So a restructuring support agreement might say the debtor has to do the following things on time. They've got to get their numbers in a certain place. They've got to get their plan proposed in a certain date. And if they don't, they've breached the agreement. Those milestones have increased dramatically over time. So this slide shows that. And interestingly, the huge jump happens in the financial crisis. So you have these agreements and the number of milestones are, around lower than 10. You've seen that first part of the graph. And then all of a sudden it jumps up. And it jumps up in 2008, right? Creditors in response to the financial crisis are saying, we want more control. We want to put more milestones, more requirements on the debtor during the bankruptcy process, right? So the code has certain requirements. We want more, and that's the way to think about debtor milestones. All right. I'm not going to talk much about this slide, but I wanted to introduce it. What we're doing now is we're kind of using machine language processing to gather trends in language. What words are moving up over time? What words are most common in the agreements? And so these are just word clouds demonstrating our preliminary result. The word provided is the most common word in debtor commitments. The word take action is the most common in the non-debtor commitments. That is a phrase that's going to be followed with a negative. You have promised not to take action unless. And so that's the most common provision you're going to see. And we don't have a theory of this yet, but we're working to figure out, like, what does this tell us? And most interestingly, how has this changed over time? One thing we have found is words that suggest financial sophistication have certainly increased over time. One word that's become more prevalent is market maker. So there's something going on where parties are putting in more sophisticated financial provisions. For future questions we want to answer in that project are, how do these affect the duration of a bankruptcy? We think that they're correlated with faster bankruptcies. That might be that they cause them, or that when you know you have a fast bankruptcy in place, you enter a restructuring support agreement. What is the role of a death trap? How does it actually affect control? Are outcomes better when parties have these agreements? And most fundamentally, are these agreements controlling hold up and hold out, or are they facilitating it? Are they creditors selling, or buying control, or are they creditors trying to silence the holdouts? The last category I want to talk about is debtor in possession financing. The agreement, so the phenomena is you have a lender who's going to finance the bankruptcy. They're going to provide the financing that covers expenses during bankruptcy while you figure out what the plan is going to be. But that debtor is going to say, here's the money, we get paid first, but if you don't do certain things, you're in breach. And so a lot like the restructuring support agreements, it's going to have milestones. It's going to manifest control over what the debtor can and cannot do. And to think about the way that the control is exercised. The money is provided, and as I said, they're going to bargain to be paid first. Right? There's 4 versions of financing to the debtor. You can give someone an unsecured claim, so just you're the same as everybody else. You can give that person administrative priority. You get paid before all unsecured claims get paid. You can give that person a secured claim secured by the assets of the debtor. Or you can give them a secured claim that primes old secured claims, right? And so these are versions, 2, 3, and 4 are versions of super priority. The priming lien is the most super prior loan. And so if you have the secured claim that primes all other secured claims, you're the safest possible position making that loan. So if the debtor breaches that agreement, that lender gets everything first. And so if they're dictating control, they have a lot of leverage. And you can see this is old data from Ken Iott and Ed Morrison, but it shows you kind of the way these loans tend to work. When there were DIP loans, you had 92% of them secured by all assets. So they opted for the secured level. If you have 95% that have administrative expense super priority, 65% would have the priming security interest. And so this just shows you the percentages where you have the different levels of priority. This slide shows you the covenants that tend to be in the financing agreement. So you've got budget limits. If you go over budget, you've breached, they can collect back the loan. You've got your expenditure limits. You've got your targets for earnings. And you can see the percentages in which those show up in the agreements. And then what do you get when the agreement terminates? Well, 90% of cases, if there's a default, the automatic stay terminates. So the creditor can then exercise their rights immediately. Right? They get power over the debtor's plans and control. That's that when we say power of attorney. All of these are the provisions that cause the breach and then the control that is exercised when the breach occurs. Right. There's been recent literature, so that data is a little old. The recent literature on this looks at the effect of these, the rates of these, and then some of the provisions. The most recent paper by Ekbo, Lee, and Wong points out the most interesting thing, I think, is these DIP financing agreements are almost risk-free. It's very hard to find a case where the debtor defaulted and the lender didn't fully recover on a DIP loan. There's one recent one in the current crisis, but prior to that, there's no major cases where the lender isn't getting paid in full. And yet the loan spreads are higher than your normal leverage loans. They're even higher than the loans a debtor is taking on the eve of bankruptcy when the risk is much higher. They have these heavy covenants, these milestones, these protections, and yet they're getting paid and risk-free returns, and yet they're getting paid better than kind of market rates. A working paper by Jared Elias and Ken Iott shows that the control in these agreements have been increasing over time. They call this bankruptcy process for sale. And if you combine the two papers, it's process for sale really good price if you are giving a loan on risk-free, with a risk-free loan on better than market terms. Sorry, I'm going to go to the next slide. To give a little more data on them, Fred Tung, my co-author on the RSA paper, he has a paper, and I think he actually presented this at one of the conferences in India 2 years ago. He has data, more recent data on these agreements since the financial crisis. And so just to quickly go through that, he shows the most common features. So he had 288 cases in his sample. 182 had these DIP loan agreements. 106 of those had cash reporting covenant. 160 had cash reporting covenants. 154 had budget reporting covenants. 98 had roll-ups. Roll-ups are where the lender in the DIP agreement is also a pre-petition lender, and they roll their old loan into the new super priority and payment agreements. 56 had these reorganization milestones, 26 was sale milestones. Just gives you a sense of what's in it. And those milestones and those covenants show you the control that is exercised through these financing agreements. They are associated with good outcomes. So emergence from bankruptcy is the kind of y-axis there, what percentage of cases emerge. And you see that if they have a DIP loan, that's the blue line, it's much higher than if they don't have a DIP loan. Again, whether it's cause or correlation is open for debate, but it is an interesting kind of combination of outcomes. Not surprisingly, the rate of the availability of these loans correlates to the market. And so what he shows here, and again, these are Fred's graphs. What he shows is that during the financial crisis, when the number of cases increased, the percentage with DIP loans decreased, right? So as you get more debtors in bankruptcy, the financing available dries up a little bit. As the world is in a financial crisis, the financing dries up a little bit. Now, in the current crisis, people were worried back in March that there might be a similar kind of DIP financing shortage, but it hasn't turned out to be true. In fact, the DIP financing market right now is quite robust, and we can see that in recent examples. So Brooks Brothers just last week or 2 weeks ago announced a 0% interest rate DIP loan. So this might suggest the market is catching up with that paper I mentioned earlier, showing that they were getting above market interest rate. Now they're getting what has to be a below market interest rate, a 0% interest rate. Now you look at it and you're like, that can't be right. What's likely going on there is they really are buying control. The lender wants to buy Brooks Brothers. The lender has agreed to finance the bankruptcy for free, and I put free in quotes, because what they're getting is the inside track on the purchase. And again, you can think, is this bankruptcy process for sale? Is this a efficient way of getting a good sale to happen? Are they trying to gain control to rule out hold up from other parties, or are they trying to exercise their own opportunistic behavior by getting control early? One final interesting recent case in the current crisis, which I think maybe one of the earlier speakers in this series talked about, is Hertz. Normally, a DIP lender gets priority. The DIP lender is going to be paid first. In Hertz, because the market was buying equity, which gets paid last and almost always gets wiped out, but nonetheless, when Hertz files for bankruptcy, people were buying that stock. Hertz proposed to the court, can we sell worthless stock to the market and get $1 billion of financing? The court said yes. The SEC hinted no, which basically killed the proposal. But it's the first time we've ever seen something like this where you're going to offer your DIP financers the worst priority. Now, why did that happen? Likely because retail investors don't understand or are gambling and just taking the long shot, which is why the SEC stepped in and said, no, this is problematic. The disclosures the SEC was reviewing said things like, you should be aware that this investment probably will get you a 0 return. And so why would anyone buy that? Again, gambling for the long shot. This is not your traditional DIP financing, but it's an interesting example. And I'll just kind of wrap up then. Why do I think this is important? As I said at the beginning, almost every major case has some version of this problem of what to do with these agreements. I think they are an example of what I believe is the fundamental bankruptcy problem, which I've been writing about recently. Bankruptcy is all about controlling holdup behavior without creating new holdup behavior. And that is a hard balance to find. Ex-ante agreements are incomplete. They are subject to abuse. Therefore, intercreditor agreements are themselves incomplete, subject to abuse. If they are opting out of rules that protect against holdup behavior, then they're creating exactly what bankruptcy is trying to avoid. If they are the parties trying to add holdup control, then they're doing what bankruptcy is supposed to do. And we need to figure that out. Ex post agreements can be more complete, but when they're being entered into, the parties are already engaging in holdup, and so we have to see and measure whether or not they're reducing holdup or increasing it. And so there's no perfect solution to these problems, but they do highlight what I think are the proper purpose of all bankruptcy systems. You need to work on three things. You have to have boundaries to exclude the most extreme behavior. If it's obvious that certain provisions are always bad, they should be prohibited. Maybe death traps fall into that category. Maybe they don't. Courts have to decide that. For provisions that are sometimes abused and sometimes not abused, you need competent and experienced judges who can make the ex post decision about that, who can figure out what to do. And you need to value assets and value claims in order to understand holdup. You have to know what damages would be for an intercreditor agreement. You have to know whether this DIP financing is a market interest rate or not. Is it above market? Is it below? And you have to know whether the debtor commitments and the milestones are following the right values for the debtor's estate. And so looking at what these parties do gives us a sense of these problems that all bankruptcy systems face. All right, that is the end of my presentation. So I think now I open it to questions.
Thank you, Professor Cassie. It was a very informative and helpful session. I now open the floor for any questions. You can type down the questions on the chat box, and if you would like to directly speak to the speaker, please raise your hands.
So should I be going through the chat box or calling people, or will you do that?
Sir, I would read out for you. I would read out all the comments and the questions for you.
Okay, great.
So we have a question from Urvashi Sahi. Her question is there any theoretical framework for judicial oversight of DIP financing?
So is there a theoretical framework for judicial oversight of debtor possession financing?
Yes.
So you can, that's, I hesitate only because there is, I'm not sure if there's agreement on it. So in the paper I mentioned, Jared Elias and Ken Ayat, their theoretical framework is that these are sales of control that judges should be particularly skeptical of. And they are proposing provisions that allow the market to compete better and let outsiders jump in to provide the financing rather than insiders. And why they're doing that, I think this goes to kind of the theoretical question. The big question is, why are lenders getting better than market rates? Why are lenders almost always, or not, not almost always, but more often than not, pre-petition lenders? So the theory is they have inside information, and the question becomes, are they abusing the inside information, or are they correcting for the fact that they can't get good information out to the market? So it's not a framework, but that's a question. I'm more optimistic than Elias and Ayat are, and I think that the ECBO paper suggests the rates being paid are too high, but these are otherwise valuable loans. And so if I was going to kind of, on my research agenda, think about it, the two things you need to control, I think, are the market rate and the way control is being exercised. The control issue goes to the fundamental theory for all of bankruptcy, and you need to rule out the extreme behavior, and you need to have judges assess the marginal behavior. I don't have a theoretical framework for marginal behavior. That's why you need competent judges. You can have a theoretical framework for how to figure out interest rates, and I think people are trying to develop that. One thing I'll mention on this, a big question is the roll-ups. So roll-ups are a benefit the lender gets if they're a pre-petition lender. Most people say what this really is a hidden interest rate. So there is a framework here. I think most academics think roll-ups are problematic because they are a non-market compensation that can't quite be measured. And why not pay with interest rather than pay with a roll-up? Because if you pay with interest, you can compare what the pre-petition lender is offering to the market and have a better sense of that. So all of that is to say people are developing it. The key questions are, how do you measure the market rate, and how do you rule out bad mechanisms of control?
Thank you, Professor. I have a next question from Mr. V.V. Anand. His question is, what is the range of haircuts that the creditors have to suffer in the US in such as RSA?
In RSA?
Yes. What is the range of haircuts that the creditors have to suffer in the US in such RSA?
So if I understand the question, I don't think there's a systematic answer. So the parties to the RSAs, and this is one thing we're studying, range from note holders to bank loan lenders to hedge funds to private equity. One question we're trying to find out is, are there recoveries associated with what party they are? Are there recoveries associated with whether they initiate the dialogue? Are there recoveries associated with how many milestones or how much control they exercise? Do parties who don't enter the RSA take a bigger hit than parties who do? We don't have data on that. I will say Momentive is a fascinating case because the senior lenders who were subject to the death trap, they were, if they didn't enter the agreement, it was about a $200 million cut that interest rate would have caused with them. And so it was quite a lever being pulled to get them to sign on. The thing the debtor wanted them to get was what's called a make-whole payment. A make-whole payment is a penalty for prepayment of a loan. And they said, you filed for bankruptcy, which caused you to prepay the loan, so you have to pay more than the loan and more than the interest. The debtor wanted them to give that up and said, if you don't give that up, you lose $200 million. Ultimately, on appeal, the court said you can't cut $200 million from them. But they also said that make-whole payment wasn't valid, so they weren't getting that anyway. So everyone would have been the same if they'd taken cash. But the short answer is, some don't take a haircut at all if they're first lien lenders. Some will take a major haircut if your note holder's signing on, but you might be doing better than you would without the agreement. In the end, we want to study the correlations between those recoveries.
I hope Mr. Anand, your question is answered. Coming to another question, sir, it is by Anuradha Malik. Her question is that DIP financing in India, can it be given creditor in control insolvency regime?
Can debtor in possession financing be given in a creditor control regime? So yes, in some cases it would be easier. I haven't studied the DIP financing in India, but I know how the credit control system works. So it should be easier because the creditors are the ones in the U.S. The pre-petition creditors are usually the ones making the loan. And so if the pre-petition, and when we say that, we really mean the financial creditors. So if the financial creditors are the ones calling the shots, the decision should be easily made to borrow the money from yourself or provide it. I'll confess not to knowing the specific rules, and maybe Needy knows the rules in particular, how the process works there. But I would think in theory it should work even more smoothly than elsewhere.
Okay. Anuradha ma'am, do you have any further comments on it? Or if we can proceed further? Okay, so yes, so she's, okay, coming to the last question, sir. This is by Neeti ma'am. Lenders might be well skittish about extending credit to a company that has filed for bankruptcy. How does the law ensure protection for them?
Yeah, so that's the outsiders would think DIP financing is really risky, right? And then I say to you, it's almost risk-free. And in times like now with Wicks Brothers, they're lining up to make these loans, right? They're offering it at 0%. The protection comes in two forms. The super priority. So the common thing is to give them a security interest, to say you have a security interest in assets. And the bankruptcy code allows the court to do that if certain requirements are met. If they get what I call the priming lien, so you have a first lien lender that already is there, and then you're giving the new lender security over them. That is to say, if the debtor defaults, the new lender gets all the assets first, to cover the value of their loan. And that's major protection. And so these lenders are looking and they go, look, what are your assets worth? If I'm going to get them first, your assets are worth $20 million. I'll give you $15 million. I'm totally protected. Now, the worry then is, what about the creditor you primed? And the code requires a strict showing of the necessity of the loan and a strict showing of adequately protecting the debtors being primed, right? And so in that world, when you're the DIP lender, you're totally protected. Often the objectors are lenders who might be primed, and the court is supposed to find that there are enough assets to protect them. There's no guaranteed protection there. On control, when I say that that's a form of protection, if the debtor doesn't meet a milestone and they default and the automatic stay is terminated, you can end the bankruptcy tomorrow and take out all the assets. And so that gives you a ton of protection. No one wants to come in at the bottom, but coming in at the top is very safe. And so that's why I say that it's almost a risk-free loan. It's not the same as loaning money to someone who's about to file for bankruptcy. And it's not even the same as loaning money to someone who's coming out of bankruptcy, because it's a short-term loan where you get this protection and this control.
Okay, Neeti ma'am, I hope Sir has answered your query. Any more questions from anyone? Okay, Professor, I think that was the last question. IICA is really grateful that you could make it here, and we hope to see you soon in campus. Times are good. And Neeti ma'am,
Yeah,
yes.
thank you, Professor Casey. I mean, it's always a pleasure to hear you. And
thank you so much for having me.
So, and we really hope that you could come spend time with us physically when times are right. The first batch of GIP has been looking forward to since the time I shared your paper that I came across last time. That was also a very interesting paper. I'm going to share with my current batch, and all the industry participants who joined us today. Thank you so much. In case you have a follow-up question, we'll be glad to receive from you. And what we do, Professor Casey, we prepare a report in the end, and we run it through the speaker. Then we run it through the speaker. So we will, in case we collect more questions, we'll pass it on to you, and then it will be part of the report. Yeah.
Great.
Any
Appreciate
other
that.
question? Yeah, in case we have no question, we could call it a day. Weber, would you like to say something? Great. Okay, thank you so much. Thanks, everyone. Thanks, audience. Urvashi, Ekta, everyone, thank you so much.
Thank you.
Yeah, see you around.